By the way, it bothers me that all the cars from Glencourt cul-de-sac parked across the street, Marionola Way, and guess what it is? Street cleaning day for our street. Well, the street was not cleaned and the truck just drove right through the street. I was outside when this happened. The street, Marionola Way, should be swept again as soon as possible after this project is completed. I don't know where the failure of communication is in the city. We have a city manager and assistant city manager, and where are they in this responsibility? I think we need to do better. Start delegating better the duties, and if not done in completing tasks, maybe it is time to do something about it. Hold people accountable for their actions. Maybe set up an informal evaluation for all employees, especially city managers, for the public to be a part of. Maybe things will get better. Accountability and serving the taxpayer should be the primary priority of your job. Thanks, Irma Rupert.
Hey, could you turn that question on the street paving over to the city engineer to reply to that? We have a schedule for street improvements, and it's been explained at several meetings by the city engineer, and we've actually had presentations on the street paving and how it is put together. So I think that Ms. Rupert needs to be informed of the process. Thank you.
Thank you, Mayor. Just noting for the record also that it looks like finance consultant Jeannie Roca has joined the call.
Thank you.
Thank you.
Hi, Jeannie. How are you?
Hi.
Pleasure having you with us. Okay, we're going to move on to the consent items. The only consent item that we have is to approve the minutes of the August 26th, 2020 meeting. Do I have a motion?
I'll move to approve the minutes.
Okay, and I'll second it. All in favor signify by saying aye. Aye.
Aye.
And Debbie?
Aye. I'm muted.
Okay. So that's a 3-0 approval. Then we'll move from the minutes to the business item. We have one item today as to review the revised procurement policy and review and provide direction. And Mr. City Attorney Cashier, if you would, please.
Thank you, Mr. Mayor. Nice to see you and good afternoon. Mayor Pro Tem Martinez Rubin, Treasurer Long, city staff, and those on the public who are listening along. Good afternoon. And City Attorney Eric Casher, I'll be presenting this item, the revised procurement policy for the city of Pinole. Next slide. By way of background, at a kind of 10,000 foot level, the procurement policy for the city of Pinole is governed by a host of different requirements and regulations. So procurement really is the city's ability and processes through which it acquires goods and services. That's really what this procurement policy is about. The public contract code in California, the government code, the civil code all place regulations and restrictions on the ways in which public agencies can acquire goods and services. To add a little bit of level of complexity, but it's important, we also have restrictions placed on us to the extent that we receive funding from different sources. For example, the state government or Caltrans. When the city of Pinole adopted its procurement policy in 2007, it undertook a few amendments, one of which was in January of 2018, where we added language that was required of the city to add to its procurement policy in order to move forward with a project that was funded in part by Caltrans and state funding. There are also requirements that are placed on the city regarding, depending on the type of funding that's received. Federal funding, for example, has its own different set of requirements. And so there's another host of requirements around federal funding. The procurement policy for the city of Pinole is really intended to provide a framework for staff and a guide for staff so that they understand the different rules and requirements and they can adhere to and comply with all the various laws throughout the state. There are a few amendments that have taken place, but as you can see, most of those were very minor and somewhat technical. There's only been a handful of amendments since 2007, and so staff felt like it was a good time for us to revisit this policy and do an amendment. Next slide. So the proposed revisions, included in your materials, you'll have your staff report, You have a copy of the revised procurement policy, and I've also included the copy of the existing procurement policy. What you'll notice probably initially, just from just a quick review, is we pretty much just replaced the entire policy. The policy that was adopted in 2007, it's a bit outdated. There's been a number of changes within the city based on the types of procurement we're now engaged in. We do have some projects that have state funding and some federal funding. We wanted to beef up some of the sections regarding emergency procurement, given the state of affairs and some of the things that are going on. So that's what brought about the interest in revisiting the policy. And then just from a practical standpoint, work closely with staff and all the department heads. There was a level of frustration, might be too strong of a word, but definitely there's some inconsistencies in the policy. And I think pretty much broad consensus among all the department heads felt like we could have something that's a little more user-friendly. It's going to be easier for the public to understand and to follow along with, and then provide some better guidance to staff. So the staff is going to, I'll be presenting this revised procurement policy for you today. I'm going to go through some of the sections that have changed, and it's our hope that the subcommittee will provide approval essentially to move this forward to the city council with a recommendation that we approve the procurement policy. So next slide. So what is new? So these are the key sections in the revised procurement policy that were not in the prior version. And I'll just go through each of these very briefly to give you a sense of why we added them. So the first section deals with contracting principles. This is basically the kind of high level policy guide for staff when they are evaluating whether or not to engage into a contract, and they're deciding on who is the lowest bidder or what are the different considerations that we undertake. So we're looking at things like making sure that there's a competitive process, making sure that we're getting the best overall value, fairness and transparency. So this is a good and important section because when staff has questions or there's inconsistencies in how to interpret the policy, this is something that we could always fall back on, look to these guiding principles. Is this getting the best overall value? Is there fairness and transparency in this approach? Is this complying with all of our best practices? So we've added these contracting principles up front just to serve as a kind of guide and framework for our overall procurement policy. We've also added a section on standards of conduct and ethical considerations. So these are requirements that already exist in the Political Reform Act and also in the Government Code, Section 1090. But this is helpful to provide staff with a framework for these are your roles and responsibilities and obligations to do contracting and procure contracts in the most highest and ethical standards. It also has some reference to Government Code 1090 and requirements for our contractors, those who we end up entering into contracts with. So that's a new section that wasn't in the prior policy. We felt like that would be good to include in there, again, as a guidepost for staff and to mirror some of the requirements that already exist under state law. Design build contracting. So this is a new and emerging area of public contracting that I don't believe the city has actually had any design build contracts, but it's something that we are seeing quite a bit of. The state legislature just adopted some new statutory language around design build contracting. This is basically when you have a public works project, and rather than putting it out, you kind of go out to get a consultant to do the design, and then once you have the design, you go out and do a competitive bid. Design build is basically hiring one construction management firm that brings in the contractor and the design professional, and it's all one procurement. The state requires that if the city is going to engage in design and build contracting, that it have something in its procurement policy. We didn't have something previously. We now have that in place in the event we want to engage in design build contracting. Competitive procurement. So this is something that the city has engaged in the past. This is where you're basically looking to other public agencies who have, for purchasing supplies, for example, if you're pooling multiple cities in the county, for example, because everyone's buying the same good or the same supply or good, and we're going to get a better deal if we're purchasing that along with other agencies. That's what's called cooperative procurement. And that's something that we had been doing, but we just didn't have a real policy in place that provided a framework for that. So we've added a section on competitive procurement in here as well. Micro purchasing is really dealing with really small dollar purchases. This is really just for supplies. It's something that's already been approved by the council as a budgetary kind of approval. It's just staff being able to go forward and purchase something that is really minor. And so it's less formal procurement requirements than would be required of having to go through some of the larger processes that we have. We have a section in here for information technology purchases. This is just to make sure that when the city is purchasing IT equipment, software, other types of technological equipment, that we consult with the IT department to make sure that there is consistency, coordination, and integration so that all of our systems can speak to each other and do so properly, and that we're not purchasing forms of IT equipment and softwares and the like that's not compatible with one another. We have a section in here for qualified vendors, and that we already have a section in there for qualified contractors and consultants. This is basically allowing for us to have a short list of qualified vendors for supplies, goods and supplies, so that if we wanted to go out on a procurement, we'd have a short list that we can, essentially go to, submit, do a competitive, round, get a couple of proposals from that short list. We now have a process in place to do that for vendors as well. And then finally, we added a definition section. The prior policy had a lot of terms in there that are sometimes legal in nature, sometimes they're loaded terms. We've added the definition section at the very end of the policy to provide some clarity in the meaning of some of the phrases and terms that you see within the policy. So those are the new sections of the policy. I'm going to pause there in case there's any questions at this time, and otherwise I'll just move on to the next section.
Personally, I think my questions will just fall as we go into each section.
Okay.
Yeah, let's go ahead and complete the presentation, and then I'll go to the public and then come back to the subcommittee.
Sounds good. Thank you. We'll go to the next slide. Okay, so these are some of the sections that already were existing in the procurement policy, but we've tightened them up and we've enhanced them. So we've kind of made them better. Sole source procurement. There is passing reference to sole source procurement in the current procurement policy, but there isn't really a thorough explanation of those situations where sole source procurement would be acceptable. So sole source procurement basically is a situation where you don't go out to competitively bid, you don't solicit proposals. The technology that you're looking to acquire or the service, the good that you're looking to acquire is so unique, only one vendor can actually provide that good or service. And so there's a process through which you can do sole source procurement and just go directly with that particular vendor. It's all provided for under state law. There's limited requirements and limited exceptions where you can do that. We've now laid that out in our procurement policy, so that's clear for staff and they have some more direction. Emergency procurement. We did have a section on emergency procurement. We've beefed it up a little bit in light of what we've seen with the wildfires and the rolling blackouts, everything that we've got going on. We wanted to make sure that we had a emergency procurement section in the policy that was going to allow us to seek reimbursement for FEMA funding, in case we needed that federal funding, as well as some of the other requirements under state law. This section does that, and so we now have that in place in the procurement policy as well. And then finally, we've added we've enhanced our section on purchase orders. That's basically a short form agreement where you're just buying, let's say, 100 widgets. You don't need a large 15-page agreement to do that. It's just a simple purchase order for those goods. We have some processes that we've beefed up and enhanced as it relates to purchase orders, and that's now in this revised procurement policy as well. Next slide. Okay, so staff recommendation is to review this policy, provide us with any feedback. We're happy to answer questions. I did want to mention one other thing. This is just the first step of our essentially revisions to our city's procurement. In addition to this procurement policy, city staff will also be adopting a procedures document, which is more of an internal document that will provide more of the administrative functional details for this procurement policy. It's going to cover things like what is the standard form agreements that you use when you want to enter into a consulting services agreement, and what is the proper approval chain of command when you want to get a particular contract approved who needs to sign certain types of agreements. So it's really more administrative. That will be a separate document that we'll call the procedures manual, and we'll be adopting that and preparing that once we have some direction from the city council on this procurement policy, because it will essentially provide the little more of the details for the procurement policy, which we have before you here. So that was really, really quick. I know it's a lot of information. The procurement policy is large in size as well, but I'm happy to answer any questions, and I know staff is here and available to do the same.
I'd like to ask the city clerk, do we have any public speakers?
Thank you, Mayor. No, we don't have any speakers so far.
Well, then I will close that portion of the meeting so we can bring it back to the committee. And I'll ask for comments. I'll start with Norma.
Thank you. I just wondered if the different sections that are now added, the revised policy as presented, at least if we take a look at the outline that you showed us, City Attorney Casher, and I went to another city, if we compare the different sections, are there any that are particular to Pinole? Or can we consider that the different sections that now make up this policy are rather comparable to another city our size?
Good question. So the sections that have been added, and really the policy more broadly, it's really a compilation of best practices that you're going to probably see in most cities that have procurement policies. There will be some unique qualities about our policy, things like the approval threshold for city manager or department head authority, or but the procedures manual will actually be where more of the kind of uniqueness, if you will, to Pinole. This is a pretty standard procurement policy that most cities have adopted. It's a very high-level document, and it's consistent with what most cities have.
Thank you. That's it for the moment.
Yeah. You're welcome.
Okay.
I did what you told me to, Heather. I muted myself. Treasurer Long, questions, please.
Just a general question, I guess, before we get into the meat of the document, is there any standard language that would follow each of these sections along? Because I wasn't always sure if everything applied to each section or if it was only as specified as you went under standards of conduct, A and B, and then when you got into another section of purchasing policy. So do they each have unique, I know some of them have unique policies, but are they all inclusive of some standard language?
Good question. So the standards of conduct and the ethical considerations and the contracting principles, those two sections right up front, that's going to apply to every form of procurement that the city undertakes, whether it's for construction services or the acquisition of goods and services and supplies. It's going to be consistent for everything. There are some, then beyond that, so that's sections 1, 2, and 3. And then beyond that, we start getting specific to the type of procurement. So there are definitely some different rules that apply to the purchasing of construction services, for example. That's typically referred to as public works contracts or public contracting. Those have different requirements than what would be required of consulting services. So it's the difference between hiring a contractor versus hiring a consultant or an engineer. And so we do have different requirements depending on the services that could be acquired and purchased, but that's really the only differences that apply.
And the other thing is that, do you believe, and I was going to ask this at the end, but I think I can ask it now, do you believe there should be a separate section for the wastewater treatment plant based upon some of the items that are common but high dollar items?
Good question. I don't believe that there should be. So my suggestion and recommendation is that the city will have the procurement policy in place. All of these requirements will apply to anything that's purchased from the city. And if there's a nuance or something that we want to have unique to the water pollution control plant, I think that's probably best housed in the kind of the agreement that we have with the city of Hercules, or the agreement that's specific to the water pollution control. Yeah.
All right. I just wanted to bring it up. Thank you.
Yeah. No, thank you.
Oh, that until we get into the actual document, that's all my questions.
Okay. I think you're muted, Mr. Mayor. I think you're on mute, Mr. Mayor.
Keep doing that. I think we'll be moving into that section right now because that's all the questions that we have and comments. So let's go ahead and get into the document, and I'll go ahead with Norma. Do you have some comments on the document itself?
I do, but are we going, oh, let's see, you want all my questions through the entire piece, and then we're going to go to the next person?
That would kind of be one way to go, yeah.
Okay, well then let me look at all my tabs. Pardon me. Just a few questions here.
Yeah.
Okay, so I am on a hard copy, and I'm on page 10. It also reads page 18 of 49. And it has, the section I'm reading has to do with maintaining a list of qualified contractors. And that appears under, in a paragraph related to informal bidding for public works projects. So my question has to do with how any potential contractor would end up on that list. How does the city maintain it? How is that list eventually created? I imagine from past experience, there are some contractors that have proven to do the work and have met all contractor requirements and would be recommended again, and therefore called upon, or at least informed about a next available opportunity to bid. But what about others who may not be on the list? How would they come to be known by staff to eventually end up on a list like this? So that's one question.
Yeah.
Well, let's answer them as they go along, so we can move through them.
Yeah. Tamara, I know that you are on the call. You're welcome to jump in here, and I don't want to steal your thunder here. Let me know if you'd like to take that one, or if you want me to take a crack at it.
I'm happy to answer that question. So it is, a pattern of behavior that we in contracting maintain basically an Excel spreadsheet. But that's old school. Currently, the city of Pinole is using a digital bidding platform to maintain its list of interested contractors. And our website instructs contractors who are interested in bidding work for the city of Pinole to go to the digital platform and register. And they can actually register showing that they're interested in jobs from Pinole. And then when we have a job that we're seeking bids for, we post it to the digital platform, and an email goes out to the subscriber to that list, and they get a note saying that we have a job to bid. And if it's an informal, then they just follow the directions. If it's formal, which we also use that platform for the formal bidding, they follow the processes that are laid out for them for formal bidding. So we still maintain kind of an Excel spreadsheet. So when we have these micro projects, we'll call 3 of the contractors that we have an established relationship with and get bids. So if there was a new contractor in town who had been registering on site, it would be beneficial for him to continually provide bids for us so that we got to know who that person was. And then, even call and say, hey, can I drop by? Because it is hard to break in if you're a new contractor into those micro contracts. But the bigger ones, we use that competitive bid platform, and the technology is there to support maintaining the list.
Thank you for that.
Just to follow up on that a little bit, Norman, before you continue, just to follow up on that. There are requirements by state on public works contracts as far as bidding documents go, and we can compile a list of qualified contractors by when the contractor does apply or a subcontractor does apply to the city to be part of a list, they have to have a qualification procedure so that we know that they can not only bid the project, but they have the capability of completing the project. So it's a little more than just putting your name on a list. You really have to make sure, and the city has to make sure, as in all public works projects, that the contractors that they're using are certified and have their licenses and have their insurances and all the other things. And so that all has to be on the city's documentation before you can accept a bid from a contractor. But it's easy to do. You just have to contact the city, and the city should have a list of procedures for a contractor to get on that list. That's all.
Can I ask one more question to Normus?
May I finish?
Oh, sure. It was on that specific item.
Go ahead.
I just wanted to know if, besides the digital bidding, do you always do all three of these as listed in here? Is it inclusive, or is it just picking what you decide is most appropriate? Because you have that you can send a notice to the city maintained list of qualified, or you can notice all appropriate construction trade journals. Do you always do all three of those items as listed, or is it as you deem appropriate for whatever is going out to bid?
I believe the way it's structured in the procurement is through a tiered system, and the lower tier, we have the ability to be informal. So we don't post a notice to newspapers, for example. In the interim tier, we also have the ability to be somewhat informal, so we don't post notices to newspapers. In that top tier, we are required to post newspaper notices, as well as, send out the notes to our list. So that top tier has the most stringent hierarchical way of handling the bid. The other two are more informal. We usually use a pattern of picking three and calling. We just had a recent experience where we had a procurement for professional services, and we have an on-call list. So we reached out to more than three on our on-call list, and nobody on our on-call list wanted to propose on the work or felt qualified or had the available resources to deliver the services for us. So in that case, we went to the middle tier and we posted it to the bid platform because we needed to get the word out more broadly. So, we appreciate the way that this procurement policy has been put forth, because it does allow us those different tiers and the different structures, while still requiring that we be compliant with public contracting law and the signatory to the construction cost accounting. I don't remember all the acronym.
Yeah. Uniform Construction Cost Accounting Act.
Thank you.
Thank you. So again, getting to that very specific thing about a list, I'm just wondering whether, because there seems to be a lot underlying what that list is, if it's sufficient on this policy document that would be made public, correct? For anyone who would read this and would want to get on that list, that if this is the place to indicate the means of getting on it, or whether it's more fitting as it may be now, which sounds to me like provided someone goes to the website and then they might get information, city website, to get information about getting on that list. And that maybe that is the correct place to find out more about that. I am just keeping in mind the matter of possibly expanding that list and not let's see, making it old. Well, it may get. I'm not even thinking about getting old. I'm thinking about trying to avail ourselves of contractors who are unfamiliar with our policy, and to the extent that they do a bit of homework or digging for the information about how to get on a list, that they would do so. I'm not saying that it's in this policy where more information about how to do that would would best fit, it caught my attention, which is why I asked about how one would get on the list. So as a matter of policy, again, I don't know if this is the best place to have any more explanation or if it's sufficient. If, as it stands, it does what staff need, then let's leave it as is.
Okay, the only thing I can add to that as a subcontractor, and I've done millions of dollars worth of public works projects. A lot of contractors don't do public works projects because they don't want to go through the necessary paperwork and the necessary forms that have to be filled out, not just before bidding, but during the bidding process and after getting the contract. So that list is limited to those who are actually, usually most of the time, have experience. You can break into it, but you have to have the ability and the resources to be able to comply with all of the requirements of public works projects. So it's more of a, it's not just a simple bid process. It's more of a process of complying with all the standards that are in place, both state, county, and city standards. And it requires more of a subcontractor. Somebody coming in who's never bid a public works project might be the low bidder easily, because they don't know what they're going to have to go through and the time and the money they're going to have to spend administratively to do that contract. So that's why the list is, it's always available, but I think we have a, and Hector, you can, or Tamara can add to this, if we have an actual procedure, a procedural format where we can inform a new proposed contractor who wants to propose to be on the list. If we have a list of requirements that would be sent out to him so he can make sure that he gets on a pre-approved list. So the pre-approved list is a question. Any contractor who calls the city and wants to get on that list, it has the ability to do that. And I believe, and correct me if I'm wrong, that we do have a procedure to get a contractor on that list. Is that correct?
Well, we have only used pre-approved lists for discrete standalone projects. And there is a procedure that goes with that. We use a structure like you're referring to within the bid documents to qualify contractors. So the first hurdle to be qualified to bid a contract with a public agency is merely the licensed contractor status. And we stipulate in our projects which contractor's license is required for the work. It matches the work. Since we do a broad array of work in Pinole, sometimes a B license is suitable, sometimes only an A license is suitable. We also have tiers of licenses under that. So that's the first step. And when we do a closed bid contract, within that document, we have all the hurdles for the qualifications, the community involvement, ethics, bonding capacity, which was mentioned, so that they can't even put a bid forth unless they can successfully execute those components of the contract. Now, again, these are for our larger contracts. They're not for our smaller contracts. So we do have a system that allows each and every project to go through a review of the contractors. We used a pre-qualifications list for our water pollution control plant, and that is very typical for a project of that size. I hope that answers the question.
And if I may, Tamara, just add, in addition, Mayor Pro Tem Martinez Rubin, good question. I made a note to myself. Keep in mind that this is a policy document that does go to the City Council for approval. So it is it's not inflexible, but it's harder to make changes to this policy document because it does need full council approval. What you mentioned is a really good question, and it really gets into the process and procedures for getting added to the short list of contractors. That's a procedural kind of administrative function that I've got a note here to make sure that we include that in our procedures manual that will help inform some of the higher level policy issues that are in this document. The procedures manual will provide this level of detail, and so we'll make sure to include that in there. So I just wanted to mention that as well.
Thank you. That wraps it up this part of it, pardon me, Director Miller, and making that distinction about what kind of document this is important. Director Miller?
I was going to state that I'd be happy to share screen if you want to see our actual web page that says, here's how you sign up to be on our list. It already currently exists on our web page. It shows the digital platform. It tells you that it's free. It tells you that the list is maintained continuously. So under COACA, we're supposed to update it once a year at a minimum. And because we use this bid platform, we can have a continuous updating process. So, and it's the first line on our page for bidding and RFPs. So it's really right there. It says, please use this bid platform to hear about our projects. So I don't think it needs to be in the policy document. Procedure document's better, and we're already executing, these practices.
Super. Okay. Thank you. So I'll move on. There's reference to the procurement procedures manual. So this is what you, I think now both of you, City Attorney Kasher and Director Miller, have alluded to is being prepared or also being looked at as you continue delving into this. Okay. I'm not sure how what I say next will apply here. I didn't see anything specific to online purchases, but it really doesn't matter how one makes the purchase. It's the matter of the amount and the type of service. Is that correct?
That's correct. Yeah. Yeah.
Although in the older policy, there is mention of credit cards, and there is no mention of credit cards in the updated one. So can you somebody explain to me why that was deleted?
Yeah, so the thinking with the removal of the reference to credit cards is because that's really more of a kind of administrative, a practical kind of issue and topic, the use of credit cards. And so that's something that we definitely plan on including in the procedures manual.
Thank you. Prevailing wage laws is just something else that caught my eye, and that appears in the definitions section, specifically under the paragraph related to public works on page 29 or 37 of 49. It's the only instance in which I saw that. Might have missed it elsewhere. But with regard to contracts and use of prevailing wages, what is it that determines whether prevailing wages is the way to go or not? He said, what determines that?
Absolutely. So there is a labor code section, I think it's labor code 1720. Don't quote me on the specific number. I think it's 1720. It defines what a public work is for the purpose of prevailing wage. And it essentially says it's any public work that is paid for in whole or in part with public funds. So an example would be if there's a private resident who wants to redo their sidewalk in front of their home, and they're going to pay for it entirely themselves, and it's only the public right-of-way that's being used, and the city's going to charge them the permit fees, the city's going to charge them all the fees that's associated with that project. So there's no public funds that are flowing to it. They wouldn't need to use prevailing wage. But if we're doing a street paving project that we're using city funds for it, or even state funds, we absolutely would require prevailing wage. So it's on a case-by-case basis that we assess whether or not prevailing wage would apply. It's a labor code requirement that flows through everything that's in the procurement policy. So we didn't feel the need to explicitly call it out for each procurement. But if the service falls within the definition of public work under the labor code, we have to use prevailing wage.
Thank you. Okay. I am now on two tables. I'm looking at two tables. One is on page 30 or 38 of 49, and the next page, 31 or 39 of 49. Now, I wasn't certain why we had two. It appears to me that the table on page 39 might have been a draft only because I see some notes in red ink that appear in red ink when one prints the document, and they seem to be questions that were going back and forth as this document was being prepared. But I'm also wondering whether they are questions to us as a committee that staff would want us to comment on.
Good question and good catch. So Appendix A, the clean version, that's the Appendix A that would be included in the revised policy. I do think that the one with the red language, that probably shouldn't have been in there. That was just our own notes as we were going through it. And just to explain this particular chart, if you recall in the prior version of the procurement policy, there was a flow chart that was included in there that had, purchases for consulting services over 45,000. This was an attempt to kind of clean that up and make it a little bit, to still have that, but rework it in a way that would be a little bit more kind of user-friendly and intuitive. But yes, the clean version is the one to have in there. And the questions I think they're already addressed in the actual final version. That's the clean version.
Okay, good. Thank you. Yes, the table helps a lot for a quick spot on which components of the policy refer to what and et cetera. And I also noticed that between the draft version and the final revised version, there is also a distinction between dollar amounts. So it's clearer, for example, when it says 45,000 or less, and then in the next row it's over 45,000. So it's clear as to where that $45,000 amount sits. Mm-hmm. Even a dollar difference makes a difference, because if it's $1 one way or another on the old table, it wasn't as clear and it would require a different approval authority, for example. So thank you for that. I think that's it for now.
Okay. Along with that, looking at that page, I think it's 49 of 49, and I'm looking at the purchasing system overview, which kind of lays out the schematic and the structure for doing it. Where it says less than $45,000 for consultant services, would these be services that the city council has approved and the cost would be under $45,000, or would it be consultant services that management decides that they need and it's under $45,000?
Good question. My understanding is that these would be consulting services. So the city manager would have the authority to award a contract in the amount of less than $45,000 for consulting services, based on this policy. See here, and keep in mind, this is the chart that you're referring to is it's the existing procurement policy. So it's the chart that we currently have in place right now. That chart has been revised in the new policy, but just kind of reading off of the original one, it would allow for bid award by the city manager, department solicit bid, department conduct interviews. Yeah, it would be a city manager approval. It doesn't get into the issue of whether or not it needed to have been approved previously by the council or directed in any formal way through a budget approval.
Can I add something there, Eric?
Yeah, please.
That's the existing process, as I understand it. So some time ago, the city council deliberated on the issue of increasing the dollar threshold of a contract that could be executed by the city manager. And I think the $45,000 threshold is the existing. So it's not, nothing was changed in the revised procurement policy to those thresholds. Your question, Mayor, does raise a good point that I think is worth noting, which is this issue of who can authorize. Basically, as Eric explained, procurement is deciding from whom we're going to buy goods and services, right? It's a separate issue from the city council appropriating money for the purchase of those goods and services. So for any of these things here that don't need to get city council's approval to execute a contract, city council needs to appropriate the funds though. So for instance, in a case of a $45,000 professional services agreement, the city council would have had to already budget an amount for a consultant to come do some work. And all that this is saying is that the city council's authorized to execute the contract, funds for which have already been approved by the city council. The city council itself doesn't need to approve the execution of that contract. And I think that
was my question, and that's what I was looking for in an answer. And it was just related to consultant services, not goods. goods and materials are entirely different subject matter. But the thing that concerned me was that I read a line, and I don't remember exactly where it was, and I probably got it in green someplace, but I didn't note it, but that department heads could authorize purchases or other types of consultant services on their own too. Is that true, or am I just not reading that correctly? This is police department, fire department, the department heads could authorize a purchase up to $45,000 if they needed to.
Yeah, so there is reference in, let's see here, I'm looking at attachment A, department head expenditures. So there is language for non-public works purchases. Department heads do have the authority to expend any expenditure, purchase, or contract valued at under $10,000 may be approved by the department head, provided that the funding for the purchase or the contract is authorized by the budget approved by the city council. So similar to the city manager's point, as long as there's a budget approval for it, then and it's a contract of $10,000 or less, the department head can approve the contract.
Okay, it's just somewhere I read where it was more than that, and I was getting concerned looking at the numbers that we have. That's all I have right now for questions. Treasurer Long?
Okay, that's where I'm a little confused, and that's why I was asking if there wasn't a blanket kind of statement that supersedes this entire procurement policy that makes those generalized statements. I think I would be more comfortable to see that written down, because there was one place, I believe it was explicit, but some of the others weren't so much. So, because as I recall, when the $45,000 was approved for the city manager, it probably never got written down, just the dollar amount changed. But at that time, it was understood that the city manager would let the city council know that they had, done something, or it would be under a consent calendar, or there would be some way that the council would be notified of the contract itself and what was approved. So I just want to pass that on, that was the way I had understood it to be in the past. And if it's not going to be done that way going forward, because it was perhaps unwritten, then that should be made just very clear, I think, through some kind of generalized statement saying that all these procurement policies would need council approval through funding with the current budget, and that there's a difference between council approval and management execution of any contracts. Does that make sense?
It does. And let me try to see if I can help address that. So section, let's see here, 4 of the procurement policy relates to contracting authority. And so this basically says all city expenditures and purchases must be approved by the city manager or department heads. And so this is the kind of catch-all, flows through the whole procurement policy section. So all of the monetary thresholds included in section B, that's basically what applies to every contract throughout the city. It's that section that really has that. We can relocate that within the policy, but as you'll see in the language related to, for example, the city manager approval, it says that the city manager has the authority to make any expenditure, purchase, or contract valued at $45,000 or less, and that may be approved by the city manager, provided that the funding for the purchase or contract is authorized in the budget approved by the city council. So this is trying to draw that distinction. Once the city council approves the budget, and so the budget has been approved, and the city manager now has the budget approval, the city manager could then go and enter into a consulting services agreement under $45,000 within the budget that was already approved by the city council.
Okay. I guess part of my confusion, because I did read that and I have that all underlined, but under the approval authority, note the contract, let's see, or the city council, no expenditure shall be submitted or recommended to the city council. No, that's not where I wanted to do. It said or, at the very front, it said or the city council. All expenditures, purchases must be approved by either city manager, department head, or city council. And I understand what you're saying, because if it's under a certain threshold, the actual execution of whether it's a purchasing of goods or a contract wouldn't necessarily need the authority of the city council, since they already gave it through the budget. Mm-hmm. I just don't know how clear that was to me. And typically, you know, I don't want to have to read between the lines to figure it out. And I was just wondering if there was any language that could be added to make that clearer.
Yeah, how about if we...
Not to me, or not necessarily to the council, but to anyone else that would be reading this document.
Absolutely. I might offer a friendly amendment to just add to the end of that sentence, so it would then read, or the city council, subject to the monetary threshold set forth below, or something like that.
Or to the, okay.
Or consistent with the monetary thresholds set forth below.
Okay.
Can I just add that we thought about this issue quite carefully when we were drafting it. I think it's a significant, I think having this section is a really nice improvement in the revised policy. And I think that last sentence under, 4A is, I read that as being pretty clear that, regardless of what we're saying about who's authorized to execute a contract, it's perfectly clear, I think, that all city expenditures and purchases, regardless of amount, must be included or contemplated in the city's budget. So again, I think that's we've bifurcated these two different things. One is basically how we select the vendor, and that's our procurement policy. The other is, everybody needs to know that you can't select a vendor and spend anything until the city council has budgeted that appropriation. So I hope I think that's pretty clear. And as Eric described, and I guess I would just describe it as a matter of construction of this policy, these sections in the beginning lay out terms that relate to the remainder of the document. And I think if there are any parts that are in conflict, we would normally take the more conservative approach, so we're not violating any provision. So I think this is pretty, okay. I know I've felt kind of proud about having included this, our team having included this, because I think it's really strengthens the document. So from my perspective, I think it's pretty clear. Okay,
and I think sometimes when we have these discussions, it obviously becomes much clearer for all of us. Okay, so I'll move along to page 3, and that's 11 of 49, but page 3, and it's the second paragraph, and it talks about the prohibited interest include interest of immediate family members, domestic partners, the respective employers, respective employers, and prospective employers. So this sentence doesn't seem to have, I mean, it's about the employees, right? Their conflict of interest.
Right.
Well, is there a reason why the city council isn't mentioned in this? I know it's assumed, but I just... Yeah.
So this Government Code 1090 relates to any conflicts in the approval of a contract. And so that's why it's in here. It applies to the city council as well as employees. The city council... So the reason I think it's in here is it's because, there are some contracts that would not be approved by the city council. So there does need to be clear reference to the fact that this does apply to employees. It definitely does apply to the city council. So we could add city council and employees as well. It applies to both, basically.
Okay, it's a suggestion. It's for, I guess, you as our legal counsel and for the city council to decide upon, but I would recommend adding city council.
I would also recommend that, and I think both Treasurer Long and myself are going back to an incident that happened several years ago where a city council person intervened in a bid process and supporting one of the contractors, and it was what we would call unethical. and what actually was an FPPC violation, but we managed to get it through, and I'm just like Councilmember Long, I want to make sure that the city council is aware that they should not be, they should be ethically bound by these contracts also. I know they take the ethics course and the conflict of interest course, but sometimes because of their association with a person that wants to bid a contract and that person really wants it, so they go to the council member and they say, hey Joe, can you help me out here, see if you can't get the city staff member to think my way and stuff like that. And so Joe goes down to the staff member and starts intervening. Those are things that I think the council has to be well aware of. May not in some cases.
So I would ask a question of the city attorney. My sense is that the city council gets counseled on the conflict issues quite thoroughly, and this is just one of many forms of conflict that a council member might experience. I guess from a practical perspective, I'm not sure whether a council member is likely to review the procurement policy on a regular basis such that it would remind them of that potential conflict, as opposed to it being captured under the regular ethics training they need to get. So I'm just offering the observation that I think that this is a really significant concern that's related to a larger constellation of issues that council members need to be constantly vigilant regarding and are trained on. So I feel like yes, I wonder if practically speaking it's going to have much influence to be placed here, because this is pretty deep in a policy document that's primarily going to be used by city staff. So I don't think there's I guess I feel like it might be establishing the expectation that people are going, elected officials are going to find it here and be aware of it tucked away here, which, I'm not sure it's needed because they get that training elsewhere. And I don't know that that's a practical expectation. So I'm just making that observation. I
would offer a differing opinion in that one, you only get your ethics training once every 2 years. And, sometimes that all of it doesn't stick. But besides that, I believe that probably many of your council people might very well look at this document. But more than that, when this is shared with the public is going to have a perception that perhaps the council is excluding themselves, even though we know they're not. I would never ever think that, but different minds think very differently. And I think it would just make this document more open for the public to know that the council members take this policy as seriously as the administration does. Because obviously this is more of guiding for you and the department heads than it is for council. But ultimately council is the one who will be responsible if anything goes afoul of this. And we won't go back to I guess it was the middle 2000s, and there was a council member that was directly in conflict with this. And I think had someone been able to avail themselves of this detail, unlike the other one that we had, as you pointed out, doesn't have the same type of detail, who knows, maybe things would have turned out differently. But I think it's important to add city council to ensure that everyone knows that the council plays by the same rules as everybody else. And it's just from a public perspective.
I appreciate that observation and persuaded by that viewpoint. So I changed my opinion. I think that makes a lot of sense when you've explained it that way.
Norma?
Sorry, I'm getting a lots of noise outside, but I would support adding reference to council members in that section.
Okay, thank you.
Okay.
I guess you have your direction on that.
Duly noted. Thank you.
And then going to page 5 under contracting authority, and this comes up, I guess, throughout the document on the micro purchases. In fact, I actually looked at the notes and where it said, do you think we might want to add a micro purchase procedure, and your thoughts? I just put yes. Is that something that will be addressed when they do the actual purchasing policies, or things like that, and define what micro is and how it might play out within the different departments?
Yeah, so good question, Treasurer Long, thank you. There is reference to micro purchasing in, let's see here, this is page 10 of the procurement policy. I believe it's page 18 of 49. There's a definition of micro purchases, and it provides some framework and restrictions. It's really the purchase of goods and services valued at under $10,000 is really what a micro.
Right, and I remember, and I think it's actually happening today. I don't know if it was ever looked at. We don't have a purchasing department per se. And while I understand that in the scope of things, sometimes these purchases might be extremely small when compared to the rest of the budget, but should there be some direction, and I'm going to use something very silly, you need a couple dozen pins, and they happen to be on sale at Staples for $5.98 for a dozen compared to the regular price of $15.98. And if departments, if there was some policy about, you know, instead of just going off and checking who they want to order from and which supplies without any thought to, you know, when sales, take advantage of sales, or if they can, or if it's up to just a department head to do what's easy, or wait until the last minute to order supplies because someone ran out of their sticky notes. It's something very small, but I believe that it would be very good to have some type of policy when it comes to those type of goods, when it's throughout all departments. It's not unique to one department or the other. There may be unique items in ordering, but typically there are some staples that run throughout the departments. And I don't think this is the document that would talk about it, but it made me think about it when I was reading it.
Yeah, I'll just add, we can certainly add some language in our procedures manual that will give some guidance to staff on micro purchasing. Right now, there's basically a reference to, you know, seeking multiple quotes and bids, even when not required, is a best practice to help ensure that we're getting the best pricing, but there's not anything more than that. We could certainly add some additional teeth to that in the procedures manual.
Okay. And then on page 6, the public works projects. And I can only try to explain what I mean by going through something that I recall. So I'm not trying to embarrass anyone. I'm not trying to point a finger at anyone, but these are it says this definition specifically excludes maintenance projects defined as routine. So I'm going to assume that those would fall under the $10,000 threshold. Or
so the public, so that's actually connected to the public contract code. So the California Public Contract Code requires competitive bidding for all public works, and it excludes the definition of maintenance in the definition of public work. So that's why that's carved out. Yeah. Okay,
but right now, Public Works has the authority to enter into a contract if it had to do with a maintenance project. And
yes.
Okay, and specifically, I'll use one is on the Appian Way project for the vines. I think Tamara will know what I'm talking about. The ones at the top, the wall right there between Sarah and Michael, and then the vines, I think just before Marlesta. And when they were getting out of hand, I believe a separate contract was entered with, perhaps it was the current service we use for gardening, and it was actually quite a bit. And I was just wondering, when these contracts are entered into, if there can be some, once again, a guiding policy that defines that they talk about how long it will take them to do a project and the cost associated with it. Because I watched 2 men do one wall for, it was 2 or 3 days, and the other wall couldn't have been any more. And so it was just slightly, probably over a week. And the amount of money that was paid for that wall, and I realize I'm not immune to the fact that I know that there are more costs beyond paying the employee a certain amount of wages. But even factoring in a lot of that, I just was scratching my head and thinking that there must have been a reason. It couldn't have been a number that was just purely drawn out of a hat. So is there anything that could be added to make sure that when these contracts that are approved by department heads, that they have specific type of criteria when, awarding the contract?
Yeah, so my suggestion for dealing with that would be to update our standard form contract for maintenance services, and we could build in those performance standards and metrics into the actual contract, because that's what we would have to enforce and to ensure performance. And failure to perform would then be a breach of the contract. And so I think it's best placed in the actual agreement. I can make a note of that because the city attorney's office obviously prepares those standard forms in those contracts. So I'm happy to add language to those agreements to kind of.
Do all the contracts also have a not to exceed? So if you were doing it by that and they estimated it's going to take 14 days and you realized no one was on the job after day 8, that you could question the amount that the contract came back at when they presented their invoice?
Yeah, the beauty of those agreements is we can tailor the language depending on the service that's being performed. So if this is the type of project and we have those concerns and we've had those concerns in the past, we could build in language to assure that time is of the essence, or there is a fixed time that they need to perform the work. So we could do that through the contract.
Okay, that was a blanket. That wasn't specific to just this type of project, but it might run across the board, and just something that when those contracts are being awarded, some of the little checkoff lists that they might want to ensure that they touched on.
Yeah.
I would add that essentially every contract the city lets is a not to exceed contract because it has to conform to the amount that's budgeted by the city council. There are two major forms of payment for contracts. One is what we call a fixed fee, and that means we define the work and they agree to do it for a certain amount, and regardless of how much time it takes them. The other is a time and materials basis, and one thing that I know that the department heads and the city attorney and we have all discussed is language in the procedures that we've been referring to that provides some guidance to departments and other contract administrators about when it's in the city's interest to opt to use, which of those two forms. And so I know that's something that will be discussed. If we think, it depends on what the price that's being offered by the vendor is, but in some instances, it's definitely in the city's interest, particularly if there's a lot of risk and uncertainty about the work, to get a fixed fee contract. In other cases, when there's, maybe we have greater certainty and we think we can get better value through time and materials, we should opt for that. So I know that's something that's on a lot of our minds, and we'd like to have some standard guidance in the procedures on it.
Right, and I'm not questioning a department head using either approach. The only thing I'd like to see is the accountability for the approach used. Mm-hmm. That's all I'm saying. And that's what everything's about these days, accountability, and why one approach was used over the other. Not because there was an uncertainty, but why was there uncertainty? It's like when you open up a road, we did this for this because we had no idea what we were going to find underneath. And that's true probably 9 out of 10 times, I think, on that one. But it's just for accountability to know why they used the approach that they did.
Understood. That makes sense.
Okay.
The only other comment I wanted to add to that was I've seen this situation happen where a contractor will, and the reason I'm saying I had a direct experience in it. I was a source contractor for a large corporation doing sheet metal work, and another company came in that did all work, not just sheet metal, but just general contracting. Their hourly price was about $4 an hour cheaper than mine. So they got that source contract, and it was renewed from then on. But what happened was, where I was charging them $24 an hour for 2 guys to go out, these folks were charging them $20 an hour for 4 guys to go out and complete the same amount of work. Let's say it was the same amount of time, but you had 2 more people on the job, but they were $4 an hour cheaper. So those are the kind of things that can happen. And if you're not, I guess if you're not concerned about the quality of the contractor who's doing the job, you may not save money by taking the cheaper bid. So that's just something I wanted to throw out.
Okay.
Wait a minute, Norma, do you have any comment on that? Okay, go ahead, Dick. Go ahead, Debbie.
Okay, so then on page 7, I have 2 questions on that. On the $200,000, and that was a figure that I did not see on the purchasing system overview from the previous one. I do remember on the wastewater treatment plant, the $200,000 was discussed and approved because of the timeline that they would have to go through in getting council approval from the Hercules and/or Pinole. So I remember that one, but I didn't remember. Is this something that has been newly added?
Yeah. So the monetary threshold of 200,000 tracks the language of the Public Contract Code Uniform Construction Cost Accounting Act. So that's one of the monetary threshold. Anything over 200,000 requires formal bidding. And so that language is in there. And I think there's a reference above it, the PCC 22002, that's Public Contract Code 22002, which is a reference to the Uniform Construction Cost Accounting Act.
But I wasn't questioning the usage in the code. I was questioning about it being able to be awarded and approved by the city manager without the council's knowledge.
So for $200,000 or less is what it provides for in this policy, and that's consistent with the Uniform Construction Cost Accounting principles.
Is that something that if the council wanted to change, they could, the dollar amount?
I believe so. We have adopted the UCC, so it's currently something that I think it's even on our website, and these thresholds are in there. We could change that. I'm trying to think. It would require, I think, a municipal code update because it's in our municipal code as well, if I'm not mistaken, and the procurement policy.
Okay, I'm not making a recommendation one way or the other. It just jumped out at me, but I would like the council to be aware in more detail surrounding that 200,000. I mean, I realize you have it here, but as far as that, it was brought up in our subcommittee meeting. And if anyone had questions about it, because it was something that was a bit different, I think, than what we had before. But once again, I would suggest that if it does go through, that the council is noticed that, there was an award and an approval of a contract for less than 200 by who it was given and maybe some of the details, and whether that is when they have their meetings with the manager, whether that's via email, whether that's under consent. But I do think the council should always be aware of those types, even though it's, I understand, approved within the budget. Sometimes that budget is just numbers within a spreadsheet, and that just for the sake of the council being advised. If the new council doesn't think that it's necessary, I guess that's their prerogative. But if I were still on the council, it's one thing that I would like to be noticed of. I understand that the policy is the policy, but I would still want to be noticed of that.
Tamara, did you have a comment?
Oh, I just wanted to confirm on behalf of Eric Casher that the $200,000 is codified in the Pinole Municipal Code. It was acted on in early 2019 by the council.
Okay. Norma, did you have a comment?
No, I was yes, I do. I'm just reacting to something that Treasurer Long has commented on. It's for the year and a half that I've been on council, it seems to me that any contract, regardless, or prospective contract, or something that's in the process of being contracted, has appeared on consent calendar always. So I hear what you're saying about council being aware of any of these. I think we have been. I don't think that has changed in the time that I've been on council. I don't think it's going to change. I think there's probably more than just a good practice of having such items on consent calendar. And maybe we can be reminded of that here in our conversation as to why these things appear on consent. I suppose there is some sort of requirement that in all the different codes that have to do with procurement somehow mesh with making it public that certain purchases are going to be made. And I know that having been someone who goes over the consent calendar documents to be able to understand them better in preparation for a council meeting, I don't believe that there has been something that has passed us without us realizing it, us being council members. So again, it requires each council member to be as careful and complete about reading their materials ahead of a council meeting.
I would agree. I haven't, I don't watch every meeting that you have, so I understand you live it much more than I am, as of today. So I appreciate your comments.
Well, and I also have a similar concern in that looking at our total overall budget and being about $15 million plus or minus, $200,000, if a few of those came along, they would certainly dig into the budget pretty dramatically. And I would want some checks and balances. I hope we have those in place because say there was in 1 year, there could be $1 million worth of purchase orders go out or contracts go out under $200,000, which I don't know that they would be approved by the city council. Would they be or not?
Yeah, they'd have to be. No one could execute one of these contracts unless it was approved in the budget by the city council. So just to respond to Mayor Pro Tem Martinez-Rubin's comments, if something falls below one of these thresholds such that the city manager can execute it, it would not appear on a city council agenda. The $45,000 threshold has been, I think, a somewhat long-standing practice. And as Tamara mentioned, the $200,000 is similar. So we're not proposing a change. I do think I appreciate the sentiment of the comments that were made, and I do think we should incorporate into the procedures manual a process to notify the council when we let large contracts, even if they're under the city manager's authority. So none of these contracts can be executed by the city manager without first having been the funding have been approved by the city council. So that's the ultimate control. And I do think it'd be good to provide some sort of a notification for items above a certain threshold. I don't think, I wouldn't want to see a bunch of additional things added to consent because I think a simple notification through some other form of the council would be appropriate. It does take staff time to make things ready for the agenda. And I think that's probably, the cost to do that would outweigh the benefits, particularly for some modest procurements. But I do think having a standard notification for certain large contracts that are being led under the city manager's authority is a great idea. And I think we should include that in the procedures.
Thank you. Thank you. Then in that same light, on the notice of completion, and I'm sure that Tamara will probably recall a few of these. The same thing I would ask that the council be notified, when they're going to file their notice of completion. There are times and have been times when council members have been notified of items that may not get transferred through to Public Works. So I would ask that prior to a notice of completion, when it is going to be authorized simply through the department, that they at least notify the council as well that it's going to take place. Some I know are under consent, but many also aren't. And on some of the, projects that maybe others haven't seen, maybe there's some information a council member would like to add before it is signed off.
So I think it's similar. Oh, go ahead, Derek. I was just going to say,
we could add that to the procedures manual, if that's helpful.
Okay, I think that would work.
Is that okay, Andrew? Is that where you're going with that?
I was going to say that sounds like a great idea to add to the procedures manual. You got to it first.
Okay. Great.
And I think that anytime you see where it's something that might intrigue the council, if that could be done, I agree with the city manager. Adding things to the consent calendar certainly isn't going to help the time frame for any of the employees or the time length of the meeting for the council members as well. But I believe that just a simple notification, however it's chosen to be done, would be appreciated. I know I would have appreciated that. So then if we go on, I think it's 13, at least that's where my notes are on page 13, under the design build, since this is a new section. And I know that I think one time it was discussed at the council level, had to do perhaps with solar. Sometimes that could be design build. Sometimes obviously smaller projects are just design build. It's much more cost efficient. But when you put those out, and this is a question that probably once again would be a policy or just informing me, when you put those out, is the budget open-ended, or is it inclusive? If you put it out for $25,000 and that includes design build, not to exceed, are there any hiccups in the design build that could come back and, make that budget expand to 20,000 or 25,000, whatever the cost that it would be? Is there anything built into the design build language to ensure that things don't go over budget outrageously?
Yeah, so the design build procurement requirements under the public contract code are pretty strictly, they're pretty strict. So first and foremost, we can't do design build for any project that is under $1 million. So that's the monetary threshold for even use of design build. And then there's a whole separate procurement process under the public contract code, which requires you to develop a short list of vendors, and then you kind of bid from that. So it's all set forth in the public contract code. We didn't include all that language in here, in part because that's, for example, a new section of the public contract code, and we don't want to have to change our policy every time the state decides to change theirs. But we'll adhere to those procedures and requirements in the public contract code.
Okay, and then once again, under the findings, it says the city manager or city council must make a finding. Which is it? And what would trigger the difference? Because we would be talking about over $1 million then, obviously, which would mean that it'd have to have council approval. So is the or a good choice of words to use?
It's a good point. The thinking here is, so there's the kind of, this is anticipating whether or not to even consider doing design build. And I think the design build contract is a whole separate process. So I think this is trying to provide the flexibility that before we wouldn't obviously approve $1 million agreement without coming to the council. But if we're just at the very preliminary stages trying to figure out if that's conceptually that could even work, the city manager, for example, would have the ability to explore that further before bringing it to the council.
And of course, maybe Roy would be one to chime in on this. My only thought is that if the city manager goes down a path that the city council says no for whatever reason, or they don't like it, or they want to see something else, a lot of time has gone into a process that may not be accepted by the city council. So I don't know if there should be discussion before that, or the city manager saying, I would like to, go down and explore this. Are you okay with that? Or because there might be people that really don't like design review. Maybe they've had a design review build project that, not design review build, you know what I'm talking about? Yeah, design build process that they've haven't had much success with. So they may have a lot of strong feelings about it. I would just think it's something that would want to be discussed with the city council prior to moving forward with just even exploration.
Yeah, there's a lot of ways that get you to a design build process with a contractor, and sometimes it's experience with that contractor in the past, knowing that they can give you a project that will suit the needs that you have. Design build is always up for review. It does kind of do the ENA type of process where you're only working with one contractor throughout the process, but if it goes above a certain number, and I think the city attorney can enlighten us on that, goes above a certain number, I'm not sure design build is applicable because of the dollar number. Would that be correct?
Yeah, so it's a floor. So if it's below $1 million, then we could not use design build.
Right.
Right.
But
so that keeps it somewhat in perspective, and again, sometimes there's a continuation of a project where a project was completed by a contractor, but we only did phase 1. We didn't do phases 2 and 3, and so phases 2 and 3 amount to estimate $800,000. So rather than going out for competitive bids, whereas the other contractors would have difficulty in completing the project because it's a tie-in type of project, we would still use the same contract on a design build process where that person would give us a design that would, and of course, they have to warranty the design to some effects too. It has to work. I mean, the doors have to open and shut, and the windows have to open and shut, and the systems that are installed all have to work properly. So that's your checks and balances on the project. But then it also has to be approved by the engineer, the city engineer, and the city architectural design process too. So all those things come into effect before the design bill actually gets awarded.
So it's likely the council would be aware of the potential or possibility even before the exploration of that project took place. Just because
absolutely.
All the other,
absolutely.
Okay.
Yeah.
Okay.
And again, still falls under the quotation mark public works entity type of project, and you have tight reins on that. State code requirements on that. So you're not going to get away with sliding something in and then charging as much money as you want.
Okay, and then on page 20, and this is probably another silly question, but criteria for preference, and it says local preference may be given to a responsive local business. What would define responsible?
Right. So that is
a length of time.
Yeah, that's language that is. So in public contracting, the city is required to award the contract to the lowest responsive and responsible bidder. And when it says responsible, what we're really talking about are they meet the qualifications of the project. So they're duly licensed. They have proper experience with the scope of work that's being proposed. So we do have the ability, for example, to reject a contractor who is not responsible, who does not have the qualifications.
Okay. Just a different definition.
Yeah.
And then we will go page 22. The top talks about.
Hold on a second, Debbie, and we're going through it. And Norma, if you've got something on a page that we slip by on the way, let's try to go page by page now, because I have something else on 20. I just want to ask a question and then move on to the next pages. I was looking at the definition of local businesses, and it defines a local business as the boundaries within the city of Pinole. And when we did the contract, and Tamara, you can correct me if I'm wrong on this, we said local businesses, and then we realized that there weren't any local businesses in the city of Pinole. So we redefined local businesses to being within a 5-mile radius or 10-mile radius, then we define them as being in Contra Costa County. And then we define them as wherever we could find one if we couldn't find in Contra Costa County. So I'm not sure how local business sometimes relates. If you can't find a local business, what do you do?
Tamara, did you want to? Okay, go ahead.
No. I concur with Roy that we went through that tiered approach as it related to the wastewater treatment plant because we did have difficulty including local people in the project. And it was helpful, but still a challenge. So I don't propose to put forth a program for this procedure document, and council happy to take direction and explore forward motion after direction.
Yeah, it's just that I want to make sure that when somebody reads this, they just say, well, I'm not a local business, so I can't do the job. And maybe we're excluding some businesses that may be qualified to do the job for whatever reasons, because we're demanding that you be a local fixed business within the city boundaries of the city of Pinole, or a home-based business located within the city's boundaries of Pinole. So I guess that's not really part of this, because this is just a definition of a local business. It just came to my mind that perhaps somebody says, well, you know, look at this. I'm a local business and I didn't get the job. I guess I'm looking at that aspect of it too. So I'm not sure that we might be handcuffing ourselves in some respects. But I guess this doesn't really refer directly to that. So I'm going to pass on that and move on. Go ahead, Debbie.
Okay, on page 22, when it talked about purchasing, the first paragraph, goods and services involving the use of federal grant funds. Mm-hmm. Typically, does the council have to approve receiving those funds anyway?
Typically, it would be. Those tend to be larger projects. The one that comes to mind right now is the San Pablo Avenue Bridge project. That is, it's a large project. Most of the federal funds that we receive are going to be for those larger types of projects that are going to have not just federal funds. So it's not going to be fully funded by the federal government. It's going to be partially funded by the federal government. So there'll still be local funds that are going to need to, that will likely require council approval given the size of the project.
Okay, so if there were smaller grants, I don't know, just someone had left you some money, or they granted you money, or however you want to say it, this council still has to accept that, don't they? Whatever is
yes.
Okay, so they would know about it. I guess that's where I'm getting. There wouldn't be any need for council approval or notification because they would have gotten that up front when the grant came through.
That's right. Yeah, and I think we have an item in the upcoming meeting where there's a receipt of a grant, some sort of grant funding. So right. Yeah, we bring those to council. Okay,
and then at the bottom, when it talks about blanket purchase orders, it says there are exemptions from purchase order requirements, and examples of such include acquiring land, utility payments, payments to other government agencies. And this is where I think about the wastewater treatment plant. Is there any way, I know that when we do sludge removal, obviously no one has, I'm sure that there's some kind of PO that might be used for that or that's signed off when they come and take it off site, or the gasoline that is purchased, or whatever energy related items might be purchased for the plant. Is there any way to include language that would make it clear that the plant might have a higher authority to exclude themselves from having purchase orders from those types of things? Or would you want to? Or do they? Did you hear me?
I'm here.
Yeah.
I'm sorry, I was on mute. So currently, that's one of the several of those areas that you touched on first I want to say thank you. Thank you for thinking of the size and the magnitude and the frequency by which we do those things, because it does make it kind of an awkward paperwork if we have to do more for the purchase authority. We take a load of sludge to the landfill 5-6 days a week, and we burn through fuel quicker than we probably want to admit. And we procure chemicals for the wastewater treatment plant and get those delivered all the time. So we have a combination of things, and I'm having conversations with Jeannie about the best way to track these purchases. And I'm really happy with this procurement policy that Eric's put forward for your consideration, because I think it's going to set us up to do some cleaner accounting as it relates to those big ticket things that you mentioned. Chemicals and fuel, we buy through one of those joint procurements that's now mentioned in our procurement policy. So that will be done through that formal process. We drive our sludge to Killer Canyon, where we have an ongoing account. That is not under a PO right now, but I know finance would like to see it under a PO so that we can do cleaner cost accounting as it relates to the wastewater treatment plant. So I appreciate you thinking about it, and I think this new policy is going to get us into a tighter accountability structure for everybody.
Okay, that's good. And let me see, I think, that's all my questions, except I had one last comment regarding, will it be seen in the policy about the internal checks and balances? I think I discussed a little bit with the city manager on that. Is that when we will see more discussion on that?
Yeah, so Treasurer Long and I and our finance consultant, Jeannie Rocha, met recently to talk about some control matters, and we've been actually making a lot of updates and improving our documentation on all sorts of accounting and control issues in the time that Jeannie has been assisting us. And so there's two things. There will be this procedures manual that relates to procurement, but some of the questions you raised, Treasurer Long, really were not procurement related. They were other cost tracking and control measures. So it's a broader issue, and my general response is yes, we're actually devoting quite a bit of attention and appreciating Jeannie's fresh eyes and outside perspective to improve some of our processes and documentation.
Okay, so that's still being worked on, as well as the actual policy manual.
Yeah, and
the policy. Yeah. Okay.
Yeah, the procedure manual that we've been talking about primarily today is the procedures underlying the procurement policy and contracting. There are all sorts of other finance-related policies and procedures, and that's the documentation I'm referring to as we're beefing that up right now, and all sorts of different areas of finance.
Almost a subset to what we're talking about today.
Yeah.
Then. Okay, great. Okay, those are my questions. Thank you.
Okay, and going on to page 23. Once a blanket purchase order is issued to a vendor, any authorized city employee may contact the vendor directly and place orders per the terms and conditions specified in the blanket purchase order. That just seems a little broad to me for some reason. I think that whoever the supervisor or the department head is in that area should be informed or should be part of that decision-making process. I don't know what the amount might be to place an order, but I don't think even though he's an authorized employee, I had a lot of authorized employees, but I didn't really let them spend my money that quickly. So I just wonder if that's a little bit broad. That's all.
It's good.
Maybe there should be some checks and balances there. But Tamara?
Yes, thank you for thinking of us and the challenges that we go through. We have an account at several of the supply houses in the area for plumbing supplies, for lumber, for pump parts and the like. And those are they're basically on call. So when we have a need for a 3x10, 16-foot long piece of wood so that we can repair the park picnic tables, one of the maintenance people will go and they'll procure it. So they're basically buying a piece of lumber. I think the piece of lumber we just bought was $450 if you want to know what 3x10 costs these days. So that's a $450 purchase that they needed to make for the park bench. I signed it.
It's hard to find a 3x10.
I know, it is hard to find
a 3x10. I didn't even know they existed anymore.
And don't ask me if that's nominal or true, because I don't really know the dimensions.
3x10. You know, you get 2 3/4 and you get 3 3/4, but 3x10.
Yeah. Point being, though, it is approved by a department head. In this case, it's done after, and those have always been our policies and procedures in the
That's fine. It's just that it looked a little broad to me. The fact that maybe a authorized employee could go out and spend a couple $1,000s without the knowledge of his supervisor or whatever. No, I understand going to the store and getting what you need. I mean, that has to be done. We can't go back for stop the work and then go back and get approval and then come back and start the work again. That's loss of time, and we don't have a lot of people out there to keep losing time with. So, no, I understand that. It just jumped out at me a little bit. And the only other one was, and I just need to understand this. This list on page 24, last part of the bottom paragraph, this list is utilized for procurements of public projects greater than $60,000 and less than $200,000. I don't remember seeing 60 someplace else. I remember seeing 45, but tell me what I'm missing with the 60,000. Where should I find that number at? It just suddenly showed up on this page.
That's one of the numbers that matches the California Uniform Construction Cost Accounting Act for the bidding of public works projects.
Okay, so we just use the same numbers.
Right, and that's in our Pinole Municipal Code that we adopted in early 2019. So it's just like an escalate. It used to be 45. So when we first adopted the Uniform Cost Accounting Act.
It just seems there's some confusion about the 45 and the 60 and how they would relate to each other. And when you would incorporate 60,000, when you would incorporate 45.
The table on page 30, or numbered page 30, 38 of 49, I find we had something similar, but not as complete in our current procurement policy. And I find that a really handy reference for exactly the reason that's being discussed here is reading through the text, there are so many different sections and numbers, you can kind of lose the thread a little bit. But I think if you look at that table, you can see where the 60 to 200 falls in. It's, as Tamara mentioned, as Eric mentioned previously, it's for public works projects
only
per the state code. So I know that we staff refer to this table quite frequently, and I would expect that any other, the council will find this a really helpful reference, as will the public when they're assessing different procurements.
Okay, I understand it now. I did actually see that and did go through it and then immediately forgot. And so went back to this and then I couldn't figure out where 60 came from. I understand it now. So that's all the questions I have. Norma? Norma's done. Debbie's done. I'm done. Did you want us to give some direction to send this back to the city council with, I don't think there were many changes. There's just a few little, I think, word changes and things like that.
Yeah, if I may, Mr. Mayor, first off, I want to thank you guys for your review and your close read of the document. It's a large document. You guys had great questions, and this really is helping us improve this. And so I want to thank you guys for taking the time, both today and then also the work that you did beforehand to review. There was only one noted change on page 2 and 3. We're going to add city council to the reference in the conflict of interest language,
right.
That early part of the policy. There were a number of recommendations made for our procedures manual, and I've got probably 6 or 7 here. I'll make sure to incorporate into our procedures manual, but I welcome a motion to approve the revised procurement policy with the noted change to the conflict of interest section so that we can move this forward to the city council.
Okay, that would be the motion to, we're going to recommend it with the change. to the city council. We don't approve, we just recommend, right?
That's correct. Yeah.
So that's the motion. Do I have a second?
Second.
No, Norma doesn't second.
No, I'm not making a motion. Just before the motion, pardon me, just little formatting change so people don't think there's some language missing. On page 28 or 36 of 49, in the paragraph that begins with piggybacking, line 3, yeah, just move up the last word services so it completes the sentence and it doesn't appear as though there's some language missing. Do you see where that is?
Yes, I've got it.
Okay.
Thank you.
Okay, and then on page 22, which is 30 of 49, page 22. You talk about how closely we look at it. Some of us look at, something just stick out for us, right?
I love it.
On page 22, section D, number 1, that line, purchase order, a purchase order is a document.
Got it. Okay.
Okay, that's it. Now the formal matter.
Okay, so those are word adjustments, not any change in the process.
Exactly.
Those are word adjustments.
Yeah.
Okay.
Thank
Okay,
you.
then the motion's on the floor and those adjustments will be made. Do I have a second?
I'll second.
All in favor signify by saying aye.
Aye.
Aye. 3-0 to recommend the policy to the city council. And thank you all for your diligence, and thanks staff for spending the time with us, people who don't seem to figure things out sometimes, but at least me. I think the other two do very well. Sometimes I have trouble. So thank you, Eric, for all the explanations. Thank you, Tamara. And thank you, Virginie, for joining in. And Andrew, thank you for your input. So what meeting will this be coming out on?
Good question. So this won't be able to get on the Tuesday meeting agenda next Tuesday, but the following meeting, I think October 20th is the next. Yeah, that's when we'll have it on.
Okay, that would be fine. Then if there's no further business, I guess, Heather, I can adjourn the meeting. Is that correct?
That's correct. Thank you, Mayor.
Okay, then this meeting is adjourned to the next subcommittee of the next sub-finance committee meeting, whenever it is. And thank you all for.
Thanks, everyone. Bye.
Thank you.
Good night.
Thank you.
Bye-bye.
Thank you.